Paragraph 8.1, we mentioned, my lord, that accused number 2 made not one confession, but two confessions. One before a commissioned officer, Lieutenant Colonel Rapadu, on the 19th of June 2020 at Moroka Police Station, and the second confession before Magistrate V. Grenier at Boksburg Magistrate Court on the 24th of June 2020, in the presence of a legal practitioner, Mr. Mjiako, who was an attorney at the time, and in the latter confession, he starts the confession by mentioning that he worked in Carltonville in 2014. This fact, my lord, is corroborated by his clocking records, Exhibit DD, and the evidence of the HR manager, Mr. Miller, who has testified in this proceeding. So, my lord, there's that safeguard of the truthfulness of what accused number 2 says. It is a fact that he works at the place mentioned in the confession, namely Carltonville mine, and he did take the police officers to his place of employment. On paragraph 8.2, he states further in the confession that he received a call from Sifiso Ntuli, who is accused number 5, to come to Basotho Hostel after accused number 5 had obtained his number from Muzi, accused number 1. He proceeded to Basotho Hostel, and Sifiso, accused number 5, called him to a room where in Muzi, accused number 1, and Sifiso, accused number 4, where accused number 5 then told him that there was a job to be done that evening. Then in the confession to Lieutenant Colonel Rapadu, he said that he was briefed that the person to be eliminated or killed was Senzo Meiwa, and that the matter was initiated by Kelly Kumalo, who was going to make payment for the whole job. Mapisa, accused number 4, was to be positioned outside as a backup. Surveillance was then conducted. They were initially in the room of accused number 1 and later proceeded to the room of accused number 5, where they were joined by accused number 3, Karos, and Mtokoziseni Mapisa, accused number 4, who is now applying for Section 174 discharge. 8.3, he mentioned further in this confession to Ms. Grenier that Karos, namely accused number 3, and Mtokoziseni Mapisa, accused number 4, called Kelly Kumalo. They told her that they were ready. They all left in a Polo Vivo driven by accused number 5. It was himself, that is accused number 2, Karos, accused number 3, Mtokoziseni, accused number 4, and Muzi, accused number 1. And to Lieutenant Colonel Rapadu, he said it was on a Sunday between 1900 hours and 2000 hours that Mtokoziseni Mapisa, accused number 4, Sifiso, accused number 5, they came across another Polo Vivo driven by one Simpiwe, that they all alighted except himself, that is accused number 2. Simpiwe gave Mtokoziseni, accused number 4, 2 firearms They then left for First Flores and proceeded to the address. A call then came through to Carlos, accused number 3, presumably from Ms. Kelly Kumalo, in paragraph 8.4. Accused number 3 called the accused 1, 4, and 5 to outside the vehicle, and they had a meeting. Mtuko Sizeni, accused number 4, then took out a firearm and gave it to Carlos, accused number 3. Muzi, accused number 1, had his firearm. He, that is accused number 2, also had a small firearm that was given to him in the vehicle. Then paragraph 8.5, Carlos, accused number 3, said they must all be positioned as they were going to hit Senzo Meiwa. They all got out of the vehicle, which was driven by Sifiso, accused number 5, to Lieutenant Colonel Rapadu. He says accused number 4 gave a firearm to Carlos, accused number 3. Then Muzi, accused number 1, was the lookout. Mapisa, accused number 4, went to stand by the window. The T, that's now accused number 2, and Carlos, accused number 3, were supposed to get into the house. When they got into the house, there is now Carlos, pulled out a firearm, ordered everyone to lie down, and demanded money and a cell phone. In the confession to Lieutenant Colonel Rapado, he said that Carlos, that is now accused number 3, shouted in isiZulu, Panzi, Mali, ne my cell phone, close quotations. And the court will remember that's exactly what the witnesses who were in the house testified. So what he says in what number 2 says in his confession, my lord, accords with the evidence of the people who were in the house. Once again, that demonstrates the high degree of probity of the confessions. Then Carlos, accused number 3, gave him a phone and a plastic bag with money. We know that the cell phone belonged to Ms. Kelly Kumalo was robbed. Hence, there is a charge that pertains to that. To the confession to Lieutenant Colonel Rapado, he says that he's the one who collected money and cell phones. So once again, my lord, this accords with the objective facts, and we have heard the evidence of Ms. Pinky Faithillingham, which shows that the cell phone that was robbed made contact with Muleleki Tower. 8.6 says, Senzo stood up to Rapado. He said Senzo jumped at Carlos, and there was a scuffle between him and Carlos, that is accused number 3. We know, my lord, all the witnesses have testified that there was a scuffle. How could accused number 2 have known about this fact if he himself was not in the house? So once again, my lord, we see the safeguard as to the reliability of his confession. It says Carlos, that's accused number 3, fired 2 shots. This once again accords with the evidence of the ballistic expert, Lieutenant Colonel Mangena. The second shot hit Senzo, but he did not see where Senzo was hit. He, that is accused number 2, left the house as Senzo was falling, and he ran out of the house to the car. He says when he ran out of the house, Mtokosizeni Mapisa, that is now accused number 4, came in. There's accused 3 and 4, remained in the house. Mozi, accused number 1, was standing outside. And when we deal with the evidence of Makaleni, we'll just briefly touch on that. It says they all came back. That accused number 1, Mozi was in front. Mtokosizeni Mapisa, accused number 4, and Karos, accused number 3, behind him. They drove away from the scene and drove to the hostel and went into a room. Mtokosizeni, accused number 4, asked Karos, accused number 3, "Are you sure you hit him?" Then Karos, accused number 3, and Sifiso, accused number 5, ordered him to go to the kitchen, and the 4 of them remained in the room. Sifiso later came out and gave him 15,000 rand. After 2 days, Sifiso, accused number 5, gave him additional money. In total, he got 45,000 rand. Paragraph 8.7. We mention once again that accused number 2 made the second confession statement on 24 June 2020 to a magistrate in the presence of his attorney. And my lord, we did mention during the course of the state case, during the course of Brigadier Gininda's evidence, that the defense themselves elicited the fact that there was a Section 105A proposal. This is a plea and sentence agreement.
Is that evidence admissible?
Well, it is not admissible, my lord, but they elicited it.
No, I understand, but I'm saying
yes,
for
yes,
judicial purposes.
Yes, no, it is not, my lord. We just mention it en passant, that they did elicit that despite the several warnings that we sounded to them, they persisted with that line of cross-examination. But we agree, my lord, that it's hence we...
Except that the court can possibly take notice of the allegations, and I'm not making a finding, of the evidence of Gininda, saying that Mr. Mjiako was busy consulting with you guys with the possibility of the settlement. He said that.
Yes, he did mention.
Yeah, no, so I'm just saying.
Yes, and
I mustn't say I'm inventing the evidence.
Yes, and Brigadier Gininda said, well, the state said I mustn't testify about this, but the more he said that, the more he was cross-examined on that fact. Paragraph 8.8, the version in both confession statements accord with the version of the state on how the incident happened, as we've met.
Festival, built better for 100 years.
How it happened, namely the 2 persons entered the house of the Kumalos on the date and time, and how he and the accused were present. The accused 3 entered the house, and the latter demanded money and a cell phone in isiZulu. And as we've indicated, this is what the witnesses who were in the house mentioned. Paragraph 8.12, Ms. Zandi Kumalo and Tumelo Madlala identified accused number 2 as one of the 2 persons who entered the house, and accused number 2 in his confession admits that he was in the house. The witnesses who were in the house testified that the gun-wielding attacker who was in the house had dreadlocks on, and accused number 3 had dreadlocks at the time. It's a fact that hasn't been disputed, as we have seen in Exhibit S. Paragraph 8.13, accused number 2 states in his confession that there was a scuffle between the deceased and the dreadlocked attacker. The witness testified about that. Paragraph 8.14, accused number 2 states in his confession that 2 shots were fired in the house and the second shot struck Senzo. The witnesses who were in the house testified to this effect, including the ballistic expert. And as we debated earlier on, my lord, that even the pathologist, Dr. Steenekamp, testified about this fact that this was a contact shot. 8.15, accused number 4 states in his confession that Senzo was shot during the struggle.
Not number 4.
No, accused number 2 states in his confession, in his confessions, that Senzo was shot during the struggle with accused number 3. The ballistic expert and pathologist confirmed that the deceased sustained a contact shot wound. Paragraph 8.16, accused number 2 mentions in his confessions that he was with accused number 1, 3, 4, and 5 during the incident. Then, yes.
Of the Evidence Act, in the sense that you make a ruling that it's in the interest of justice to admit certain evidence, like you are arguing.
Yes.
Even if it deprives an accused person from cross-examining. Are you with me?
Yes, yes.
Am I correct that that
yes.
issue has not been settled in our law?
Yes, okay. Indeed, my lord. And as we go along, we'll be referring to Himstra, where he says this rigid approach should be jettisoned. In S versus Mulimi, 2006, volume 2, SACR 8, the decision of the SCA at 9 paragraphs B to D, the SCA held that, and we quote, however, while the rule against hearsay was rigid and inflexible, the Evidence Amendment Act 45 of 1988 Act had created more supple standards which allowed the admission of hearsay evidence if it was in the interest of justice. But this runs counter to section 219 that you will refer to.
Yeah, except that in Canada, the position there is static, except that they equate it to our section 35.
Yes.
Are you with me?
Yes, the federal rights of accused.
The rights of a fair trial to an accused, whether it can supersede section 3 of the Evidence Act.
Yes.
Those reasons which make you decide that it's in the interest of justice to allow certain evidence, despite that fact. I think the case is what? State versus, not the Canada case, the ones we allude to. That case of the robbery of 34 million rands in Natal. You remember the State versus
Family, I'm back again. This is Zebra Family Channel. Family, let's talk about this today. What really happened when Baloyi, which is the state, responded to what Advocate Ngumalo has alluded to in his presentation on the 174. So Baloyi has responded. You know, there's something that bugs my mind, and I'm failing to understand what is really happening here. And I'm trying very hard. I hope everybody who follows the case really tries hard to understand what is happening in this case. Let's start with Mapisa, which is accused number 4, standing outside. Because now, what has been presented by Baloyi, countering what Advocate Numalo has presented for his client. So what he is saying here, he's saying Mapisa was outside, which is accused number 4. So if Mapisa was outside having a gun, because these people had a gun, let's put our mind together now and try to understand whether this makes sense or it doesn't make sense at all. Mapisa, okay, say 2 people have entered the house. Say, let's give example, Ntanzi and accused number 3 enters the house. And this one is outside, watching outside so that those people cannot be arrested. Or whatever happens outside there, he's having a gun. He himself, Mapisa, as Baloyi is saying when you listen to this video. So him having a gun, not only one person ran out of the house. The first one was Longwe Twala, who had his own cell phone with him. That's point number 1. And there's somebody who's watching from outside who is Mapisa, who has a gun. These people have come to rob there. They don't want to go to jail. The Longwe Twala walks out and Mapisa does nothing to him. And after, I think it's the first or the second gunshot, Mapisa ran inside. Already Ntanzi has run outside. Before then Ntanzi ran outside, there's this other guy who jumped the fence to the Ngashe family. All these people are jumping, and Mapisa, who is accused number 4, understood so that they said he ran inside the house according to the evidence of Brigadier Kininda and what Baloyi is alluding to the court to believe. This is really back in my mind. You can't have myself, I cannot wait outside knowing that my colleagues are inside. They are there for a job, to get whatever we have discussed to get or whatever we came out to do. We don't want to be arrested. We want to disappear without any trace. Then now we are making this mistake. The one who's standing outside, who is watching everything that is going on outside. It just does nothing to Longwe Twala. Longwe Twala just walk out. And the other guy who jumps the fence go to the other side. Then again, Ntanzi ran away. After Ntanzi has run away, he runs into the house. Can anybody who has his mind function properly, can anything like that ever happen? And it's being presented in the court of law. And it's being broadcast everywhere. People are watching this thing is live. Is our justice system has turned to be a mockery, or our country is becoming a banana republic? What is going on here? Another thing that Baloyi said, he said, when this guy wielded the gun, he told these people to lie down. As far as I know the evidence, the person who entered the house, according to their evidence, the state and the Brigadier Kininda, that guy took a gun and he never told them to lie down. He said cell phone and money. But today, what Baloyi is presenting in this court, he said this guy wielded a gun, and the gun that he wielded, he told these people to lie down. He tried to speak Zulu, Baloyi, though the Zulu failed him. But he tried to speak the Zulu, telling these people to lie down in Zulu. Something that, in the evidence, as far as I know the evidence, what I know for a fact is that when the gunman, according to the state witness, if there was any intruder that entered that house, he pointed the gun and he requested for phones, money and phones in Zulu. That was it. Because take for instance, this guy, okay, he pointed them with a gun, he told them to lie down. Everybody's scared of a gun. How did they wake up from the ground, Meiwa, and run to that guy who's wielding a gun? It's impossible. So those are kind of things. And there's something that is tricky in this case. Baloyi, he's saying all these things that he wielded a gun. But what he's not telling the court, that the eyewitnesses who were inside the house saw the gun and they said the gun had a wheel. He is not talking about that, but he is skipping that when you listen to this video. He doesn't want to talk about things that jeopardize their case. He wants to keep the case straight. So anything that would jeopardize their evidence or their case, he doesn't want to speak about it. But eyewitnesses, they say, the gun that was there, they only pick on things that are useless. Talking about cell phones, runaway cell phones, and all these kind of things that are useless. In the house, we are not following Longwe. He left the house. He had his phone with him because he was able to run away if there were any intruders. But running away with your phone, knowing that your girlfriend is inside the house, you are not making any attempt to call the police or to call, even if he called his father and say, hey, Kelly is being attacked here. Kelly is home and this is what is happening. I think even Chico Twala was going to call the police and tell them to rush there. There's something happening in that house. But there was nothing like that. Even though that Senzo has been shot, they are not calling an ambulance. And one of the Ngashe's guys, the son of the Ngashe, he jumped to the fence and he found Meiwa lying down, according to the evidence. That we know. Because if you follow the case, you know the evidence very well. But now, what we are hearing in this court is kind of crazy. There is no way I can let my partner in crime going in the house, me standing outside with a gun, and when people run out of the house, I don't hold them up, and I still run inside the house to do what? To do what? It doesn't make sense. The case is weak, but they are trying to make this case strong. Even the judge, at some point, he tries to bring things that he say, this is what happened in the filling station, petrol gas station. What happened, there's a guy who saw people, and listening to that evidence as well. People seeing somebody in the gas station, in the filling station, whatever you call it. Then again, how did this person know that they were going to Kelly's house? Now that from the filling station, now he is in Kelly's house. Was he a relative of Kelly? That maybe that person left that filling station going to Kelly's house. Then he finds the same people in that. It doesn't make sense. Dots are not connecting. Family, what do you think about this? Please drop your comment. Don't forget to like, share, and subscribe. We are being made easily in this case. What do you think, family? Just drop your comment respectfully. Don't forget to like, share, and subscribe. I'm coming back with another one, a hot one as well. Bravo, bravo, bravo.